So yeah, it's a great pleasure to be here with Ms. Nappinai, whose work has been kind of instrumental in actually creating a safer environment for women and children online. So we'll start off. So online violence against women and children and the marginalized unfortunately reflect the realities of the offline world to a terrifying degree and are far more challenging to legislate in digital spaces due to the lack of regulation, due to lack of checks and balances in place to defend against these transgressions. So you have very compellingly argued for this idea of a continuum of violence between the offline and the online world when it comes to these factors. Could you maybe describe a little more about what you mean by that?
Absolutely, Padmini. The construct of continuum of violence is about how violence permeates or percolates from different mediums, and it in a way remains the same, and yet the impact varies depending on the medium. So I assume that you're referring to the article I've written about misogyny online. And what I was arguing in that piece was about how, and I trace it from, actually I start with Draupadi's Vastraharan, and I trace it from these constructs of how from then till now, we continue to blame the victim. We continue to anchor the crime to certain actions that the victim may have committed or done, and almost make it seem like she brought it upon herself, right? That's the first stage of the proposition that I had put forth in that. And then I move on to the fact that often people assume that something that's done virtually is not physical. So if I abuse you online, it's just virtual. It doesn't harm you. So what are you really complaining about? And you'll be shocked to know that when victims go to give complaints, they are still met with this kind of resistance, even for prosecutions to commence. And therefore, I've taken it to the next level in terms of the continuum of violence aspect to show that the impact and the harm is as much online, if not more, because the reach is much wider. So when you have violence against a woman one-to-one, that harms her substantially, physically and psychologically. Then you have it with a closed-door environment, and there comes in the Draupadi anecdote, and that brings it to an audience. And then you take it to the virtual world, then you're dealing with a situation where you are exposing a victim to harm, and to, in many of these instances when victims have been interviewed, they have said that when this happens online, every time somebody views this kind of a post, I feel violated again. So the harm runs to several millions. And that's why I've said that the contrary to perception, harms online are actually worse than what you would see in terms of the physical domain.
Yes, absolutely. I mean, we've seen now recently in the Sulibai, Bullibai case, where it seems like the only crime that has been committed by these women is having a profile photograph with their Twitter account, right? And so it really kind of, obviously that kind of abuse really curtails people's or women's kind of feelings about their safety online, right? They kind of tend to, engage less, feel like they cannot, they self-censor, right, as a consequence. So, and I think what's really interesting for me, as you were saying, is that this continuum of violence, this idea that it is, different online is also now beginning to change with this kind of idea of the embodied avatar, right? Like, so we're hearing so much now about Meta And there's these virtual spaces where we've already had 3 or 4 awful cases of women being violated in these virtual spaces because there is this avatar that represents their body. And this is also not new. In 1996, I think, was the first case of a cyber rape, right, in cyberspace, right? So this is something that we've been contending with for a very long time.
Yeah, if I could just expand on
Please.
this, it's a very, very important aspect which you've brought up. And in fact, I had spoken on this just yesterday because of the Facebook, or now Meta, report that's come out about the exponential spurt in violence online. So just to explain it further, in 96, Dibbles wrote about this incident and he called it a rape in cyberspace. And he talked about how and this is one of those, and it was not a 3D virtual experience the way metaverse functions. And metaverse is not just 3D, it's not just about virtual reality, it's immersive reality. So the whole idea of the metaverse is for you to feel as if you're actually there. So if we were conducting the same program on the metaverse, we would be sitting wherever we want to in whichever part of the world, and so would you all. And you would be signing in whichever avatar you choose for the day. And everything is supposed to give you the experience of actually being physically present. So when a violation happens in a medium like that, the whole construct that has been put forth is that you feel that violation as if it has been physically committed on you. And the 96 incident was in a 2D environment. But that was a villa with multiple rooms where people could choose to go sign in and in different avatars. And they could then engage in conversations with what they believed were like-minded people.
Mostly text-based. I mean, the whole thing was done by text, right?
And no, but also
avatars were there, but the whole communication it's not like now when we have,
correct.
and mic.
So that's the technology more than the thing, the experience. Yeah. The experience was real for them.
Yes, absolutely.
Because this person he hacked into the system, he took control of the characters and then started making them perform sexual acts. And that every single victim said that it felt like they had been violated. And move forward to the metaverse, one of the most recent cases was of about, I think, a 43-year-old housewife who was getting into the metaverse, online gaming on the metaverse for the first time, and she was immediately subjected to sexual abuse. So often I'm asked, and just to touch upon the legal aspects of it, often I'm asked, where is the remedy? Because, the metaverse is new. Indian Penal Code happened when we didn't even have technology. Information Technology Act is now 22 years old, etc., etc. But here is my answer to that you always have remedies. So when you talk about a rape in cyberspace, when you look at the word rape, obviously the virtual rape will not qualify for prosecution under 376 IPC, which mandates a physical violation. But having said that, it doesn't mean you don't have remedies. As I told you, the miscreant had to hack into the system for them to commit this violation. And that act of hacking is a criminal offense. So you can't look so literally to say we don't have any remedies. You have to look at what is the violation, and then look at what is the law, and look at the underlying law. Don't look just at the headings. That's very superficial. Often, I find even practitioners making this mistake. So go deep, and you will find your remedies.
So you're saying that it's more an act of imagination almost to be able to look for those remedies and to kind of maybe...
Not imagination, no? Reality.
Reality, okay.
It's a reality check actually.
Right, that
because people, lawyers are always accused of being very creative. But believe me, law is not creative, law is not imagination. Right. It's as real as it gets. And that's actually the foundation for any society to be formed itself.
Right. Absolutely. So coming back to, because you did mention Facebook, obviously it's very difficult to ignore the role that platforms play in this kind of regulation. And I think in the case that we were just talking about, Dibel's anecdote, obviously there was a case of this hacking into, but what we are seeing every day is much more quotidian, right? In that I can just be online in any of these platforms and face this kind of abuse. So, and this is, of course, not only India alone. All over the world, there is a struggle against big tech, to regulate big tech, to kind of impose some limits. But could you maybe talk about a little bit about your work in this space in India, kind of trying to regulate big tech and the context in which you arrived at
Thank you
that?
so much for that question, Padmini. Very, very important issue. And yes, it is indeed an uphill task. And that's not just from me or from India, it's all over the world. They have
Absolutely.
been seeing this, right? Because on one hand, big tech plays a very important role in all of our lives, in our everyday life. Who amongst us would not want the kind of facilities, infrastructure, opportunity that big tech has placed before us, right? We want it. But having said that, does this, does the necessity obviate the need for big tech to shy away from their responsibility? And should that responsibility be enforced through law or regulation, or should it be self-regulation? These have all been the questions that have been plaguing this particular domain. And broadly, it has grown from self-regulation to soft regulation, and now over the last few years, even before COVID, and more so after the COVID pandemic and lockdown and the higher impact in terms of our reliance on digital spaces, it's moving towards hard regulation or strong regulation from across the world. I'm not just talking about India here. So just to give a background, because I digress from the Facebook report to the other earlier incident, recently, Facebook has, a couple of days back, come out with a report which talks about a huge spike in hate speech on its Meta platform as well as in Instagram. The Instagram spike is as much as 86%, in fact, of hate speech. A lot of it is misogyny, right? And we are here to speak about the kind of problems that are faced by soft targets like women and children. But this kind of a problem is actually worse for, when we go beyond the binary in terms of gender. And of course, children are a very, very soft target, and therefore we need protective mechanisms to come into play. So before this Facebook report has come, I think sometime in March 2022, the Council of Europe came out with a report. And they talked about the kind of impact these kind of hate speech, or I would put it as violence online. Because it's important for us to understand it's as physical as it can get. And I'll take a short detour here to explain why I'm emphasizing it. You will be shocked to know that there were a catena of cases in the US pertaining to child sexual abuse content, where the courts held that a virtual crime is a victimless crime. And they actually acquitted the criminals. It took an appellate authority to intervene to stop this spate of judgments being perpetuated. And then they were all reversed. So we always look to the West for a lot. So it's important to also look to their mistakes and learn from it. And here is one of them, where we look at virtual spaces and assume that it is a victimless crime. So it's not victimless, it's not just psychological, it's always and mostly physical. It results in loss of life in many instances. Therefore, when the COE was looking at all the trends in terms of the increasing toxicity online, what they advocate is, as the first level of protection, is strong regulation. So that's why I said that it's not like India is trying to regulate. And the reason I'm emphasizing it is, we have seen from the beginning of this year a lot of resistance to the kind of regulations that India has brought in, where a lot of people think or are made to believe that it is likely to restrict their free speech. It is not. As long as you have social media, as long as you have microblogging sites, and as long as regulation, in fact, restricts heavy censoring by the sites, your free speech is safe, right? But to regulate the site is meant to protect you as a user. It is not meant to restrict your rights as a user, and it's important for each of us as users to know that. And here is the role I had played in this, and to come to the crux of the question that you asked. It was a very important and important journey for me, a sort of revelation of sorts. And as lawyers, and I was an idealist who chose law as a profession, and I was one of those persons who announced in my 7th grade that I'm going to be a lawyer. And I'm so glad to say that after nearly 31 years of practice, the flame shines as bright, the passion also. So for someone like me, to have that one case, which kind of like has redefined, I would put it as, to be able to contribute to justice delivery systems. That itself is kind of like, that makes it worth your while for having undertaken this journey. Of course, it continues. It's hopefully for a much longer time. But here is what happened. So in February, there was this case that happened as a suo motu case before the Supreme Court. And this was the shocking background to it. And when I first read about it, when I was writing my book, I could not believe it was happening because I started practice as a criminal lawyer. I could not wrap my mind around the fact that miscreants will actually upload evidence against themselves. I'm talking about actual rape and gang rape videos being uploaded online. Why would you upload evidence against yourself? And having done that, why hasn't law worked the way it's supposed to do by apprehending those miscreants and putting them behind bars, by prosecuting them quickly and ensuring that they are punished? None of this was happening. And the worst of it was, victims wrote to the platforms for it to be taken down. And let me also clarify, these were not content in the darknet or, in hidden spaces. These were all on social media platforms or sites which we would all frequent. Okay? And when victims wrote to the site, they just got a standard response about the request not meeting community standards. No community standard can permit that kind of content to be uploaded. But that probably happened because it was a standard button and a standard response, therefore, that they got. They wrote to an NGO which is Hyderabad-based called Prajwala. So Prajwala wrote to the platforms and still did not meet success. So they wrote a letter to the Chief Justice of India, which was converted to a suo motu writ petition. This was in 2015. I was appointed as amicus in 2017, February. And thereafter, in April 2017, a government committee was formed, and I was part of the committee also. And this also, I'm also a trained mediator. And I have always batted for mediation as a strong solution, particularly for a very litigious country like India. And here is mediation in action, because the entire process in Prajwala's case was consensus mode. So through consensus mechanisms, technology companies were made party to the proceedings. They were all made part of the government committee's proceedings. And we put up certain proposals, and some of them, to be very precise, 12 and a half proposals. You may wonder why half, but that's the way it was. 12 and a half proposals were consensus proposals which were put before the court, and it was made an order of court. And once you have an order from the Supreme Court, it becomes part of the law of the land. Precedent law also forms part of the law of the land. And as of February 2021, when the intermediary, 2022 if I'm not mistaken, the intermediary guidelines captured a lot of Prajwala's order, and now it has become part of the law of the land also, in effect, through regulatory mechanism. So very briefly, what it did was, we were able to convince big tech to show that probably because there was a very neutral button, like nudity, the response was not what it was meant to be. So today when you go to most of these platforms, you will have a specific report button for child sexual abuse content and rape and gang rape videos. So you may have wondered why so specifically, rape and gang rape videos. It's thanks to this case. And I can proudly say it was India's Supreme Court which led the fray. Around that time, I was visiting the US also, and there was a lot of talk about such vituperative content online, and the US was still grappling with a solution. Thereafter, the G7 met, and they came out with what is called as a charter on cybercrime, and they list one of the solutions as something that big tech could do using artificial intelligence. And that's one of the consensus proposals which was already captured 2 years before the G7 charter by the Indian Supreme Court. So the long story short in terms of Prajwala's case is, one, what I learned was the problems may be complex, but we need to look for simple solutions. Secondly, consensus mechanisms can achieve a lot more than adversarial litigation, particularly when you're talking to big tech where there is a lot of mass support and everything that you do is going to come under the scanner. If they can volunteer and say, okay, we understand this is necessary and we'll do it, then isn't that the better way of moving forward? And three, we need enforcement. It's fine for us to keep asking for more laws. After the Nirbhaya case, a lot of sections were included in the Indian Penal Code. How much has it been a deterrent? Right? So it's not enough for us to keep increasing the laws of the land. Whatever laws are there, it's important for it to be implemented, to be enforced. We need to show that the laws actually work. And then the first purpose of law will be met, which is to play the role of deterrence, to stop the crime from being committed. And that's the hope I wanted to carry forward. And in fact, this case then led to the next step of my journey on Cybersathi.
So would you like to maybe say a little bit more about Cybersathi?
Thank you. Yes, indeed. So, I've been teaching judges and police and training them, and also disseminating a lot of content in terms of cybercrime, cyber laws, and enforcement mechanisms, and, most importantly, how you can apply existing law to these evolving scenarios. Because you can't always keep waiting for laws to first evolve. And laws will always follow technology. To assume that it would preempt or predict may not necessarily happen. But that doesn't mean that victims should feel that they don't have remedies. And about 2016, I've realized that I may have been missing one of the most important stakeholders, right? The victims. So it was important for me to carry this message of hope that you do have remedies in law. You should not be falling for blackmail. You should not be silent in the face of violence against you, even if it were digital, right? More so if it is digital. Because the whole construct that I built Cybersathi around firstly is, I've been a criminal lawyer from inception, right? And then I moved to IPR and then cyber laws as a specialization. And all through this journey, what I've seen is that whenever somebody is in trouble, the first person they reach out to is a friend. They certainly don't reach out to lawyers first. We may be the last in line probably. But most often, or most victims do not feel comfortable, particularly the younger generation, don't feel comfortable reaching out to parents, to adults, or authority figures. All of them play a very important role to ensure protection and prosecution, but they cannot be the first responders, right? So that's why I call the organization Cybersathi or Cyber Friend, because you need to be a better cyber friend, right? And the next step is for you to be a better cyber friend, you have to know better. So empowering through knowledge. I've always relied only on one yardstick, and that's been knowledge. I've always believed knowledge can get you ahead, And that's the message I again took forward with Cyber Sati, to empower youngsters particularly. Because, and I've used Prensky's digital natives to digital immigrants, and said that, we need to get digital natives who already believe they know everything about technology to also know about the threats and vulnerabilities that technology brings to the fore. And instead of us trying to tell them all the problems that prevail, why not let them know and let them tell us? Because if they know and they think they have to be our guardians, they will also protect themselves better. So that was the whole construct, and Cyber Sati is all about spreading hope. That you can protect yourself through knowledge. God forbid you fall victim. It doesn't matter. Don't blame yourself, because we talked about blaming the victim. Others do it still. But the first person to blame the victim is the victim themselves. So it was important to educate them enough to know that you should not blame yourself. Don't feel shame. All of us can fall victim, right? Anybody can be in your position. So you get over that initial resistance to speaking out or reporting a crime. And then the next step is for them to understand that for every single victim who remains silent, there are likely to be 100 more victims, maybe millions. Every financial fraud has taught us this, that for every victim who remains silent, they have enabled and emboldened the criminal to commit crimes against thousands or millions, right? So we need to ensure that we speak out and at least protect yourself and protect others too. And finally, law will only work if you reach out. Otherwise, it's happy to remain a spectator, right? So you need to get the law in motion. As I told earlier, if we show that enough times law has been used, enough times victims have reached out, then the system does not have a choice. It has to work. And when we make it work, doesn't matter even if it's a 50-50 chance. Life doesn't give you better chances than that, right? So even if it's a 50-50 chance, take it. And if you make the system work, then the first step which I mentioned about deterrence will happen. Once there are enough stories out there saying, so-and-so was apprehended, so-and-so tried to blackmail a girl using videos which were either shared inadvertently or voluntarily taken together. Everybody is adventurous today, We are armed with a very powerful weapon in our hands. So if people think that they want to use it, voluntarily, or it has been misused against them, it doesn't matter. Both ways, if someone threatens you by saying, we will expose this video or imagery online, if you don't do, it is still a crime. So often victims don't realize that. They think that, I shared it voluntarily, what if? What if I'm blamed for it? What if the police say, why did you share? What if the police say that you shared it voluntarily, so it's not an offense? Am I going to be judged for it, etc., etc. So it's important for victims to know that it is still a crime because they did not consent for it to be shared online. And they do have remedies in law. And that's the hope at every step, be it in terms of cyber bullying, cyber stalking, what I just explained is called colloquially as revenge porn. I just call it sextortion or cyber extortion, and or financial crimes. It doesn't matter what, speak out, because when you do that, then you're likely to get justice. You're likely to protect others and yourself from falling prey. And I can tell you, please go online and read all the stories from all the victims. You will realize that every single one of them, after they have spoken out, have said that I felt ashamed. I didn't want to speak out. Finally, I just took courage and I did. And now I feel so much better. And one lady who fell for a romance scam, and she was about in her 60s, mid-60s or something. And she talks about the same journey of feeling shame and blaming herself, etc. And then she spoke out and the culprit was apprehended. This was in the US. And now she has started a non-profit to help victims who are in similar situation. So look at the kind of courage then you gain. Instead of just having self-pity or blaming yourself, you then become the messiah for others. So this is the journey I hope to take everybody along with me as a cyber sati.
Thank you so much. That's incredibly inspiring. And I think I'm very glad that you mentioned the word consent, because obviously we tend to think of the use of the word consent only in sexually violent crimes. But even something like financial extortion is, again, it is a matter of, uncontinued consent, right? And something that is really troubling is now how the two crimes are collapsed into each other. So you have financial extortion scams, which then circulate pictures, compromising pictures after hacking somebody's account, and then blackmailing people. So it kind of exists in all these combinations and permutations. And I think having an educational resource as to what actually constitutes consent and the fact that it is not perpetual, I think is incredibly important for everybody to know, not only women or children. I think for everyone it's incredibly significant. So just to come back to what we were saying a little earlier about the kind of outcome of the Prajwala case, and about the use of AI. So recently, obviously, one kind of landmark case that has obviously not been resolved is the Sulibai Bullibai case. Just to give brief context in case you're not aware, it was basically the use of Twitter profile pictures of Muslim women, which were then used by a user on GitHub, which is a site that you put code repositories, to kind of basically act as if to create an app that sold them. So obviously it is incredibly demeaning and violent as an act. But something that we encountered while we were trying to get to the bottom of how this case might be addressed was that GitHub themselves, who are located in the US, have certain rules about doxing. So doxing is when you use information about the victim that kind of reveals their real life address, their real life phone number, which constitutes what we call real world harm. And the GitHub terms say that if somebody is at danger of encountering that real world harm, that they will take action. But however, in this case, they didn't. And one reason might be because it is in India, but also because, and the interesting thing about the Sulibai case was that it had happened once before. And again, it happened again, which is, caused a lot of uproar, because had this AI kind of solution worked, then maybe, it would have been picked up. But what that does highlight, I think, is this kind of tension between, and coming back to also what you were saying about free speech, that as users, we have rights. So, many coders said that I don't want AI kind of scanning what I'm putting online because that is my right, versus how do we kind of ensure justice in these spaces. So if you could just maybe address that a little bit.
Thank you. Again, a very, very important question in the context of the narratives that have been happening from January in India. Just to expand what you mentioned about users saying we don't want AI monitoring us. That goes also to, users of chat apps, which have encryption technology. So the number of times I've heard people who say that, oh, the reason I use this chat app because it says it's encrypted. I don't want that to be violated, etc., right? So here is the information for everybody. Where do you think all those ads are coming from? So corporate surveillance is already there. So what we are really talking about is government surveillance here. And what I would, and this is what my concern was when I was trying to contribute in terms of the outcomes from Prajwala. The first was, I have been a free speech proponent all my life. I'm not going to change today. I haven't. I'm all for free speech, right? But as a practitioner, as a user, and as a person, I have always understood that free speech comes with reasonable restrictions. free speech can never extend to harming somebody else. It goes back to even school days, Alpha of the Plough or something we read then, who said that your right only extends up to the neighbor's fence, or your arm can only reach out as far as the next person's nose. It can't go beyond that. Right? So given that kind of a background, we understand that there are restrictions. But how many people who use this catchphrase free speech understand this? How many understand that it doesn't matter if you're on an encrypted platform? It does not give you the right to violate law. You spoke about 2 instances. Well, let's also talk about the instance in terms of students of a school starting a group on a chat app and using it to do a comparative analysis of women, and to also share about what they would like to do to those women. And it's not permissible. It is not backyard conversation or playground conversation. These are all violent actions which will have consequences. So this is in fact one more message that Cybersati has been carrying forward, which is that my biggest concern was, if you look at the cases that have been happening of late, the demographic is increasingly decreasing. And I use those words in juxtaposition on purpose, because you had teenagers committing hacking crimes, etc. Now, it's not even teenagers. One of the recent reports talks about, a UK report on crimes, talks about 9 and 10-year-olds committing crimes. So you have children committing crimes, and you do not want a nation of criminals. So it's very important not only to protect so that people do not become victims, it's equally important to protect children from becoming criminals, right? So that's just on an aside I wanted to touch upon. And that ties into the question that you asked in terms of AI, and is it really surveillance? Is it really going to take away my rights of free speech? It may. We cannot shy away from the fact that if you have a weapon strong enough, it may be misused. But merely because you apprehend misuse, you cannot shy away from applying a very successful tool for either fighting crime today or preventing it. So the whole issue, therefore, in fact, how the committee also happened in Prajwala was, during arguments, one of the suggestions I had put forth, and it was based on my practice as an intellectual property rights lawyer. So you have a lot of copyright violations online. Before a movie comes out, you'll have pirated copies all over the place, right? So one of the ways that was combated was to deploy hash values of those copyright protected content on the servers of big tech, etc. And if somebody tries to upload pirated content, it will be blocked at the stage of upload itself. It's called passive filtration, because it's of identified content, right? You already know this is the content and you have to filter it out. So my proposition was, if you can have AI fighting, for copyright, why not for crimes? And to balance out the free speech aspect, why not do it like a quarantine? When I proposed it, we hadn't had the pandemic. Today, everybody can understand the quarantine process, right? So my whole construct was, nobody is going to be harmed if the upload is delayed by 2 hours, 2 days, or whatever time, right? So if AI can do, and this is something which was already, studies had been conducted, and there were a lot of robust papers on what is called as active filtration, which is of unknown content, and where it said that you could use multiple parameters to teach AI and to identify content which has nudity and harsh sounds, violence, etc. And you can isolate it, and after human intervention, if it is found to be just news or a movie, or in wherever it is permitted, if it is simulated content, etc., then you allow it to be uploaded. If not, it gets blocked. Or I also propose that the user who's uploading can be given the opportunity to also explain for speedier upload, right? All of this protects victims. We have had a system which ensures human rights by saying that, no person, 100 criminals can go scot-free, but an innocent person should not be prosecuted. That's the golden thread of jurisprudence. I stand by that. But that's equally important to say that victims cannot be deprived of their rights too. And the whole construct of Prajwala was to evolve victim-centric remedies, without compromising our fundamental rights. It cannot, right? Nothing that the Supreme Court does is going to violate our fundamental rights, obviously, right? So here is the thing. AI is a powerful tool. It's already being abused, and we are already batting for regulation to ensure that it's not just government surveillance, but also corporate surveillance should be scuttled, should be restrained, should fall within the parameters of reasonable restrictions, etc., right? But having said that, if you have usage which can protect victims, if you can have victim-centric propositions and processes, then why not? And from 2017 to 2022, a lot has happened. So if the platforms are talking about an increase in hate speech today, they have also spoken about how they have come to know about hate speech. It's interesting to know it's not based on user reports. It's based on AI finding these hate speech comments. So that's how far something that started with Prajwala has come. And this is the kind of impact judicial interventions can bring about. And I'm very, very happy and proud to say that this is what the Indian Supreme Court did for not just India, but for protection and victim-centric remedies across the world.
Thank you. So I think something that I think kind of continues on from what you've just discussed, and I think most people who use social media would be aware of this, is the idea of content moderation by people, right? So there are individuals also behind flagging things. But something that we find is often challenging in, say, the Indian context is that for example, slang or slurs that are used are often used in such ways that they escape moderation, right? Because AI might be trained to pick up certain words, but when they are used very cleverly, it might not be able to respond. So could you maybe talk a little bit about the...
Again, thank you for that. See, sometimes there's so much to talk about, we tend to miss the obvious, right? So one of the most amazing things that came out of Prajwala also was understanding the Indian context, particularly in terms of the number of languages that we have, and most importantly, the harm of transliteration. Yes. And also of using shortened slang, right? So one of the things we did was we created, and again, this was one of the consensus proposals which was made in order of court, a word bank was created in multiple languages, English as well as multiple languages, including possible transliterations and those slangs, colloquialisms, shortened formats, anything that AI picked up as a repetitious process, right? So it's kind of like, there is a synergy in terms of how AI needs a lot of data for it to build itself, but it can also feed that same data also. It can kind of guide how you feed data to it. And that also requires that level of analysis. So one thing, again, which was ahead of its time was understanding the need for vernacular languages and for remedies which will impact that. So what we did was to start off with this process of creating a word bank of keywords, and if you use all of that, and that runs to several hundreds, by the way, by now, or maybe even 1,000 now, and these are used to put up warnings. So if you search today for child sexual abuse content or rape and gang rape videos, you will immediately get a warning on top saying that doing this is criminal, it's illegal, etc. So that was the next step of it. So everything happened kind of like sequentially also. Even this AI aspect of it, at that stage, the represented company stand was that it was technology which still had to evolve for real-time deployment. So the consensus proposal was for developing that kind of AI. The deployment aspect was not a consensus proposal. So that remained to be implemented, and then COVID happened, etc. But I believe from 2017 to now, it's already being shown to have been deployed. And therefore, we can definitely increase the use cases if we want in a positive way without it being misused for restricting free speech. So, when we talk about free speech, one of the other things, because you mentioned this earlier also in the context of violence against women and children online, I just wanted to point out, we spoke about why users should not be scared of regulation. It's not meant to restrict, it's meant to enable. And why do I say this? How many of us feel comfortable speaking our mind online the way we believe? We would be very measured in our statements. We would type something out, check 10 times before we press that button to upload, right? And even thereafter, we would still keep evaluating whether we need to take something down. So when we were arguing, in fact, in the Aadhaar matter, we called it, and this was literally what permeated all arguments for Aadhaar, was the chilling effect. And why is it that we forget that free speech is as important for the probable victims too, right, as it is for others? So the chilling effect here is that if you apprehend violence against you, if you apprehend that you're going to get a huge backlash in terms of what you're posting, then you're just going to stop yourself from posting. And you do post, and you do become a victim of, let's say, trolling, etc. And then you're told, why did you even post something like this? Blame the victim, right? And then the next thing, walk away. Take it down. Why don't you just stay away from social media for some time? One of the saddest instances of this kind was in the US. It's called the Gamergate Scandal, where these ladies are actually reporting about online gaming. So it's a very male-dominated domain, and here are women who are excelling in their work, and they were getting trolled. And when they complained, these were the remedies that... So why I'm pointing out the Gamergate scandal is to show that these kind of solutions about, asking the victim to walk away, etc., are not just India-based. We keep blaming India for everything. Don't. Blame the world for it. It happens everywhere. So these kind of things are also taking away free speech. And therefore, I say that regulation, if it is properly done, can actually enable instead of being a restraint. And so that's, of course, the next step of what Cybersati is doing, which is to play a role in terms of policy making and the evolution of cyber laws for, at least for now, for India. And hopefully this will be then the lead for the world to follow. I always believe we should stop looking for precedent from across the world. We should start leading now, So here is what we can do, and here is what we should do. We as users need to be really responsible in terms of how we use technology. We cannot assume that free speech means it's a free-for-all. Free speech means it's a ticket for you to, it's a, get out of jail card, or, you're not even going to be put in jail card. Free speech means you have the right to speak your mind, provided you're not violating a law in doing that. Provided you're not harming somebody in doing that, right? That's the restriction, your hand only up to the other person's nose part. That understanding needs to... Nobody spoke about free speech till recently. Now everyone thinks that they are an expert on free speech. So it's really important for them to understand what really is the meaning of free speech. The second part, as I said, is for victims to speak out. And for all of us to feel a lot more comfortable to use online platforms, because it's no longer just about speech. It's no longer just about expressing ourselves. It's now work, it's business, it's a place where we live often, right? So restrictions because you fear cannot be the basis.
No, absolutely. I think during the pandemic, I was looking at I've forgotten what the organization is, but they look at sexual harassment in workplace. And Zoom cases of harassment kind of, peaked during the pandemic. So it happens everywhere. And also kind of coming back to what you were saying about Gamergate and just kind of bringing this back to kind of real world harm. Brianna Wu, who was one of the most important people in the Gamergate scandal, one of the women who was targeted. I mean, she was told that she was going to be shot if she gave a talk at the University of Texas. Right? So exactly. It really kind of translates into very, very real world violence. So the last question that I want to ask you, which kind of comes back to what you were saying about policy, is, and I think I really appreciate what you're saying, that it doesn't have to be us looking abroad, for precedent. We can set precedents here. There's an academic who is actually incidentally on the Facebook oversight board called Nicholas Souza, and he came up with this idea of digital constitutionalism, right? This idea that maybe we can, because it's the World Wide Web, maybe we can legislate for an international kind of, a framework. So what would you say, what are your thoughts on that, and how can India maybe contribute to that?
This is something, in fact, I've already written about. That forms the last chapter in my book also, as well as the article you were referring to, or for IT for Change, I'm an optimist still. 31 years plus, and I'm still an optimist, So this is my construct. Whenever you look at the way, law is municipal, it's territorial. Law can only be applied within the boundaries of a nation. How law transcends territories is, and this happened, and this is the interesting thing which I found when I was doing deeper, when I took a deep dive in it. It follows trade and commerce. So when maritime trade grew, you needed laws to transcend borders. So then you have what is called as soft laws or treaties and conventions, etc., which lay down a basis. And then nation states which adapt that soft law have to make it part of municipal law. That's how law transcends borders, by harmonizing laws in multiple jurisdictions. And it's not like this has not been attempted for the cyber world. One of the earliest attempts was the Budapest Convention, or the Convention on Cybercrime, as it's the official name for it. But it was predominantly looked at as a Western document. India is not a signatory to the Budapest Convention, and this is one of the reasons that's stated. The other reason, of course, is that the Budapest Convention's provisions mandate sharing of data, etc., and there was a lot of fear of getting overpowered by the West, where it's a West-made convention, which it was not inclusive whilst it was being formulated, and therefore would nations which sign up to it then be stuck with provisions which they may not be able to comply with, or they would not wish to comply with. These were all the fear factors that restrained large-scale adaptation. So one thing which in fact I have closed on the chapter was that why do we always have to keep looking out? We are one of the strongest nations now. We have a voice. We have learned to use it. We have started speaking out. So why don't we now lead? Because now when you look at it, you have about 4 or 5 conventions which are very regional, which have cropped up. I'm talking about the Budapest Convention also as regional whilst I say this. And then you have something coming from the Middle East, and then the North and South Bloc, etc. Each of these have regional adaptation, but not global. Now, you need to understand that certain nations have certain fears. But there are certain aspects which are common for all. Why can't we take baby steps and ensure that there is harmonization of laws with respect to those common areas where there is no contest, where all nations think alike? I'll give a simple example of child sexual abuse content. Right? There, Budapest Convention was one of the first to flag that we need strong laws to combat CSAM, as we call it. India is not a signatory to the Budapest Convention, and yet one of the amendments that were brought in to the Information Technology Act in 2008 was of 67B, which dealt with child sexual abuse content. And our law is a lot more stringent, particularly when you read the IT Act along with POCSO, and you have, therefore, a lot of protection of children, but it has to be implemented again. But at least the laws were adapted. So when we talk about CSAM, globally, it's zero tolerance. There is not one nation which says, oh, we don't want to regulate CSAM. We will, nobody wants to give a free run for, miscreants like that. So you pick those kind of situations, you can move forward. Why are we only looking at the contentious aspects? That Russia and China will not want a free and free-flowing data or open internet, etc., whereas the West would want it. So we want to categorize one as the bad guy and the other as a good guy. How does it help anybody? So this is the consensus mechanism, which again I would hope that is implemented globally, and why not India lead from the front in terms of, because we are literally centrally located also and central minded, so why can't we move the narrative forward to ensure that there are global legal frameworks or model legal frameworks that are evolved, which can be adapted, and then move forward from there. Where there is no consensus, let nations worry about their own territorial or sovereign rights. Nobody is going to give up their sovereign rights just because the digital domain is seamless, right? So these are just some remedies that I've already written about. Sorry, I took a lot longer on that question than I intended, but I'm very passionate about this one aspect because I find it very intriguing that law followed trade and commerce without demur. In terms of adapting model laws for arbitration, model laws for various processes which enable trade and commerce. Why? Let's come to cyber itself. Our Information Technology Act emanates from the need for India to adapt the model laws for e-commerce. That's how the IT Act came about. It didn't come about for cybercrimes. So when it came to commerce, we were so happy to adapt. When it comes to crimes, then every nation's fear of losing their sovereign rights just holds them back. So we need to ease that a bit without giving up our sovereign rights, but understanding that this harmonization will help us to fight crime better. So if we could do that, I think that's the way to go. Yeah.
Great, thank you so much. So I'd like to, there are not many of us, but in case there are any questions, I think we could take some questions now.
You were talking about international laws and the lack of international laws in cyberspace. If you see other domains, so for example, say marine laws or even space, the international community, quite quickly came up with, a set of international laws that worked well and it's still holding good. Why do you think we are struggling to come up with a consensus when it comes to cyber?
Oh, yes. In fact, I've written about that also, Karthik. Thank you for the question. The construct was about the global commons. You have the high seas and the space laws, as he rightly pointed out, etc. Everywhere where you have common land or common natural resources, which you do not want one particular nation state to have a monopoly over, and you want to ensure, because you don't want might to rule. You have the global commons, and you would therefore ensure that you adapt model laws, and it's open to all. Curiously, when it came to the cyber domain, it was evaluated on whether it should be treated on par with global commons. But strangely, one of the delineations they make is, they say that the rest of it is natural resources, whereas this is man-made. And therefore, we don't believe that global commons should be applied as a construct. I don't see how it makes a difference. But whatever I could see, both in terms of what I have studied academically on this topic, and what I have seen in practice at policy making level, and also at ground level. I believe that the first level of resistance actually comes from the fact that criminal law is always looked at as hard law that is purely the domain of the sovereign. Trade and commerce are treated very differently. So the minute it comes to criminal law, the minute it comes to enforcement mechanisms, and the minute it comes to sharing of data with respect to that, as long as it's consensus based, as long as they have the right to say no, nations are all cooperating. For instance, there was this one case where a person landed in India from outside India, and at the airport he was apprehended. And he was found to have something like 26,000 imagery of child sexual abuse content. So the question that arose was, how did they find him? So it was actually due to cooperation by Interpol and the local police, etc. Based on information which Interpol had gathered, they were able to capture him or arrest him here. So don't assume there is no international cooperation. That would be very, very wrong. There is international cooperation. A lot is happening, particularly to fight cybercrime. But when it comes to inking it, when it comes to putting it in writing, then the fear happens that if we sign something, then we are bound by it. So do we risk that, or do we just keep it more loose and decide case-to-case basis? But that doesn't help in the long run. We need to have certainty in terms of cooperation, and that certainty will also cause fear in the minds of the criminals. Again, the deterrence aspect. I personally feel that's what is lacking most in cyber, and that's where my fear emanates, that we are not really sending the correct message out, that you can be tracked, you can be traced, you can be prosecuted, and you can be punished. If we set that example, and for which we need international cooperation, if we can do it consistently, that's when the deterrence aspect will come forth. But here is, to answer your question, it is this fear in terms of the sovereign's right to legislate. And to what extent are we willing to give that up, particularly when it comes to the criminal enactments.
Thank you. Do we have any further questions?
Hi. So I understand that there are legal remedies. The slide is a bit overbearing. There are like legal remedies such as Section 498A, but I understand that as it's being utilized on the grassroots level by women who are facing crimes such as acid attacks and domestic violence. I forget, this is purely domestic violence if I'm not wrong. But what I understand is in India, if that is applicable on that level, does it also apply to the cyberspace level?
If I could just paraphrase to understand your question, is your question that you have penal provisions under the Indian Penal Code which deal with physical offenses against women? So can these provisions be used for digital spaces also?
Yeah, but also I understand that there's a huge conflict between how these cases are being construed, and I think that this whole blame the victim culture is permeated everywhere. I don't understand how remedies for that could occur.
Yes. So this is why I mentioned that you have to do a deep dive when you're trying to figure out remedies. Because often people assume that technology is evolving now, so where could possibly remedies have been built into a pretty old law, right? So you have to look at the actual provision to find your remedy. So blaming the victim happened when it was a physical crime. It will continue to happen for virtual also. But victims have to take courage and to move forward, and they will realize that they will find their remedies then. There are innumerable examples or illustrations from India itself. So one of the cases was very sad, I mean, like this was a case of morphed pictures. So I'm using this also to explain to everybody out there that it's not just about your imagery, which may be nude imagery, even if it is fabricated. It could be morphed imagery, it could be even a deep fake. using your imagery, even all of these can be restrained. You know, to threaten to circulate those or to actually circulate those are also offenses. So this was a case down south where this girl's morphed imagery was circulated on a WhatsApp group. So the girl was bold enough to give a complaint. Her family supported her. Unfortunately, the investigation was slow. And in the meantime, the blame game started, with the family then blaming the girl, questioning her again, are you sure this is not your image which you have shared, etc. And very, very unfortunate outcome where this girl then committed suicide. Her suicide note is available for everybody to read online, and I can tell you it's one of the saddest. And she talks about how, the people who first supported me had themselves turned against me, like her parents themselves didn't believe me, therefore, and etc. But look how the law then moved forward. They then found out that this was one of those, a person who was in the neighborhood, okay? And he had created and circulated it, and they applied what is called as preventive detention laws. So preventive detention has been there way before technology too, right? You have the Constitution dealing with preventive detention laws and how it should be formulated. But that's what was applied to apprehend this person and keep him behind bars. Thereafter, regular Indian Penal Code provisions were applied, and one of the provisions which often is missed out, this was modified based on the Information Technology Act, which are the provisions for forgery, 464 to 471 IPC. So if you look at those, they deal with making of a fake record. That was modified to include making of a digital record also. So morphing a picture will amount to fabricating a digital record. So you could apply that provision also to combat morphed pictures being circulated. Of course, you have provisions under the Information Technology Act, including of 67 and 67A IT Act, which deal with dissemination of obscene content or sexually explicit content. And if it is your own imagery, then you have 66E, which is of violating privacy. Everybody reads the caption privacy and assume it deals with anything and everything to do with privacy. It doesn't. It only deals with dissemination of imagery which contains private parts, which you had reasonable expectation of assuming nobody would have access to. And in that, and that's where people get confused, that if somebody voluntarily shared or if somebody voluntarily agreed for some recording to be made, then they cannot complain about it being disseminated. That's where they're wrong, because the section is very precise in saying that if you publish, transmit, or capture, so for each of these you need consent. If it is only a consent for capturing, it does not amount to implied consent for publishing and transmission. And therefore, if somebody has your imagery, which you may have shared voluntarily also, they do not have a right to share. And it is an offense, therefore, under 66E, if they share. So I hope this answers your question to the extent that, yes, of course you will face obstacles. Yes, of course you will face problems. As in this case, and this is what I've written about also, my next book is coming out in a month's time. And what I've done is I've tried to use this form of, narrative to explain what are the threats and vulnerabilities online, and particularly for the younger generation, and what are your remedies. So don't assume that the world is a big bad world and it's better that I hide from it. You can't, right? You can't shy away from technology also. You have to be out there. Then what next? How do you protect yourself and how do you find your remedies? And this is something you will find a lot more of from this book, which is soon to be published and launched.
I have just one more thing, two more. So there's also the fact that Me Too happened. I don't understand if it was a fiasco or not, but on a real life level in the West, it's affected a lot of people. Ostracism being one of the main things that affect people who go on the lines of Me Too. But what I understand is that even Big Pharma, they rolled out drugs called the hashtag #MeToo drug for this. And doesn't that make it a punitive damage? So there's that element. And then there's also the fact that in terms of the perpetrators and rape culture, how do you make that connection? Where does this all begin? Where does the violence initially begin is also the question. I'm sure there's deterrence and everything, but there's also the fact that at some point, for the violence to have been instigated, the violence should have started somewhere.
Yes, very, very important question. Thank you so much for that. The first part of it, in fact, I can tell you from my personal experience, the Me Too movement was actually much needed. And despite all the backlash, it had a lot of positive effect also. The most important of which I would like to highlight and then move on to the second question, which I really would want to address, very, very important question on that, is that, we had I hate the short form POSH Act. It's the Sexual Harassment Act, right? The prevention of sexual harassment. So that was, and the Supreme Court with angst noted that it was being followed only in its breach, despite repeated case laws from the Supreme Court saying implemented. So you had the Vishaka guidelines before the 2013 Sexual Harassment Act. Even that was not implemented, and then you had the act itself. But what the Me Too movement did was every single corporate woke up to the fact that they need this to be implemented. So I can tell you for sure that that's what I'm talking about. And remember, I already told you I am an optimist. I can't help it, So you need to see that any movement will have a backlash. But did it have a positive effect? Did it tighten something? Did it create better laws? If it did, then we have succeeded already. Even in policy making, often I see that I may succeed only 20%. When we ask for something, it's kind of like, there's always bound to be resistance. So if you succeed 20%, that's 20% more than what you had before. So you need to really look at how far you have progressed rather than what you could not achieve. And I can tell you that one step can then become a giant leap later. It always takes that little momentum and then the exponential growth can happen. And now, I'm so sorry, could you please recapture the second question that you asked on that?
So I think, I'll paraphrase and you can tell me. So basically I think she was saying, like, where does this all begin, right? Like, obviously patriarchy,
yes.
But, where does this impunity come from?
Yeah,
right?
the reason why I said that was too important, and I kind of skipped through when I was talking about the Prajwala case, and how I was talking about how I was shocked as a criminal lawyer that people will actually post things online, right? So Suler writes about this. He talks about it as, he talks about the disinhibition theory. And I have called it the disassociation theory because I personally felt one is that you drop your inhibitions when you're dealing in the digital domain. Because you're talking to a screen. You're interacting with a screen. You're in the safe environment of your home or maybe even a locked room, your bedroom, and you think you're safe there. And you think whatever you do there remains within those four walls. It doesn't. Right? So the reason why I said disassociation is because I used the Lady Macbeth thing in that, where she could instigate a murder and act like it didn't happen, but then it came back to bite her, where she then starts dreaming about the blood in her hands. So I use that example in my book to explain the disassociation theory. Often, people do not even realize that they are committing a crime when it's on the digital domain. So Suler talks about how where users drop their inhibition and they are happier to share. He calls this aspect the toxic disinhibition. And he says that just like how users drop their inhibition, criminals also drop their inhibition. Law restrains them from and makes them perform or act in a particular way. Whereas in the digital domain, that restriction automatically, we may, violate certain laws in India with impunity, thinking that we will get away with it. When we go abroad, the same person will be so well behaved. In India, if there are enough news articles about how somebody jaywalked and they were arrested, then tomorrow we will wait for the signals to change and then go across the road properly, right? So society lays down that inhibition. Society lays down those parameters. And that societal restraint gets disinhibited when you go online. And that is why when, and the Prajwala case is of course an outlier, because you have a physical crime that is committed and then a recording of the physical crime is what is being uploaded online, and there it's not just about disinhibition, it's about brazenness. It's about, people assuming that they are not going to be found or prosecuted, right? They somehow assume this kind of protective cloak around them. So that's a different issue altogether. But broadly, the trolling, the bullying, the stalking, everything, and if US courts could think that it's a victimless crime, why would the criminal not think that? So there is a lot of writing about the psychology of the digital criminal or the cyber criminal, where they really assume that they are somehow not bound by these legal restraints which apply to the real world. They assume that this is different. The persona which lives in this world is different from the avatar online. And that's why I call it the disassociation and not just inhibition. Inhibition is only about us dropping our restraints. But disassociation is about thinking, I didn't do it, that person online did it. And that's the scarier part of it.
Which is so strange because we now have real name policies, right? So on Facebook, you are actually who you are, and it's not an avatar, so to speak. But even then,
Padmini, you pointed out to a very important aspect earlier. I just wanted to clarify on that also in terms of the metaverse crimes we are talking about today, etc. So, when you talked about the what Facebook initially called the Supreme Court of Facebook, etc., right? So even for the metaverse, after the Dibbles case, all platforms were told to put in place self-regulatory mechanisms to ensure that if somebody violated an avatar's right also, what would be the action that would be taken against the miscreant? So today, when you're talking about metaverse and metaverse crimes, your first level of remedy can actually be these self-regulatory mechanisms within the platform itself, which you can utilize for availing of remedies against the miscreants. So a lot is happening and evolving. The speed of it may not be necessarily as fast as we want, and the other aspect of it, and which is why this question becomes important, is how much of the psychological aspects are being taken into account. I'd like to close out with this incident. We have talked about offenses against women and children. We have also briefly mentioned about how offenses are not really binary. It goes beyond that to all genders, right? Let me close out with this incident, again on the virtual platform. So this person talks about how he was in an online game. And I'm sorry I let out the, So it was a male who had created an avatar and he was on an online game. And another avatar violated his avatar. Okay, he talks about the sexual harassment in the online gaming process. And the interesting part there was, I do not know why this person decided to create a female avatar, but the avatar was female. It was not a male avatar which was being sexually harassed. It was a female avatar. Yet, the victim still talks about how he felt violated. So, I don't think that this feeling of violation when you are subjected to a crime online is just with respect to women and children or certain genders, etc. It's for all. So when we're talking about remedies also, we need to evolve remedies which will be gender neutral. So today when we are applying general laws under Indian Penal Code, a lot of it evolved after the Justice Verma Committee report, after the Nirbhaya case. So they're all gendered. So to a large extent, actually, we have a lot more provisions for protecting women and children. And again, my biggest concern is it's not about provisions not being there, it's about them not being implemented sufficiently or effectively. So you have it. But often I hear about how men and their rights have been violated, and they always feel that they don't have enough gender-neutral provisions. And I keep guiding them to 66E and the IT Act, because all the IT Act provisions are gender-neutral. And I tell them, don't think that you don't have remedies, you do have, So they do have, but as we go forward, if we are going to evolve special laws for AI, for combating AI bias, for instance, for these kind of evolving crimes, I think we also should start looking beyond the binary, looking beyond just the marginalized, beyond the soft targets, and ensure that everybody is protected equally. On that note, over to you, Padmini.
Thank you so much for that. So yes, I mean, it's been a brilliant conversation and I've learned a lot. I hope you have too. And I think if there's one thing to take away from this is to hold platforms accountable, but also to hold each other accountable and to know that there are ways to do so. So, and if you need to know how to do that, go to Cybersati. So thank you so much.
Cybersati.org.
.org, yes. So thank you so much for this.
Thank you so much for this conversation, Padmini.